25th. We have a few things we're going to try to get through this afternoon, starting with H2, the draft number 4.1. Unless we have like draft 10.1, we really haven't been having fun. But 4.1, we're getting close.
We're still in the beginning.
Yes, yeah. Hopefully not with this one.
Right. Single digits. Good afternoon, everybody. Eric Fitzpatrick, nice to see you. Here with the Office of Legislative Counsel, here for the Office of Legislative Counsel, I should say. And as the chair said, turning to draft number 4.1 of the proposed amendment.
Bless you.
Of the proposed amendment to H2, which you may recall has gone through a few different iterations, and you'll see yellow highlighting used in this draft, which indicate where the changes have been made between this draft and the previous. But I can give a sort of high-arching overview of what each section is to kind of refresh everyone's recollection. Hopefully will segue us into what the proposed changes are in this draft, at least. So turning to the first topic, which is the delinquency jurisdiction of the family division, you may recall that this piece of the bill was actually what was in H2 as it was originally introduced. So back in that version, other than the highlighted piece that you're looking at, the bill as introduced, essentially right now, the way juvenile jurisdiction works in the family division is that there is a minimum age of 10. So that's the lower end. If you think of it's sort of the other end of the raise the age, right? Because the lower end is 10, but the upper end is 18. Under raise the age, it would be 19. And what I say, what we're talking about there is the age range of children that would go into the family division if they committed one of these unlawful acts that's not part of the Big 14. Any other criminal offense, they go to the family division. So the proposal in H2, and this is line 13 of what you're looking at here, this is as it was introduced, was to bump that minimum age from 10 to 12. So 10 or 11-year-old charged with a non-Big 14 offense, whatever it may be, could be theft, could be shoplifting, whatever it may be, some non-Big 14 misdemeanor or felony, 10 or 11-year-olds would not go into the juvenile proceedings anymore in the family division. It would start at age 12. However, there is an exception. That's the highlighted language that you're looking at. There is an exception in current law. As we say, hey, generally speaking, the lowest age is 10, but you see there's an exception for an allegation of murder. So if the offense is murder, then there is no lower age threshold. You see, an individual who is alleged to have committed an act before attaining 10 under current years of age, that would be murder, that's would still be going into the family division as a juvenile proceeding. So in the bill as introduced, it's sort of parallel, excuse me, in addition to bumping up the minimum age from 10 to 12 for offenses generally, it does that same thing for murder. That's the bill as introduced. The proposal you have in front of you modifies that further, proposes to have the murder exemption struck so that as a result of that, all offenses that were committed by someone who was under age 12 would not go into the family division, would not be juvenile offenses. Now you see there's this one exception for murder that it would get rid of that exception, essentially is the proposal. So that if the child is under age 12, the family division wouldn't have jurisdiction over the proceedings. Could be a chin proceeding, could be something that the DCF would deal with, in a termination parental rights proceeding could be relevant there, but child would have to be at least 12 to end up in the family division.
So as it stands now, say if somebody 10 years old murdered somebody and they were found guilty.
Well, it wouldn't be criminal in that case.
Oh, okay.
This is talking about, in order to be criminal, generally speaking, it has to be at least 14.
Right, okay, and that's kind of where I was going to. They would only be potentially, I guess it would be institutionalized at that point till they're 18. Is that right?
Well, that sort of goes to the whole, like, what facilities does DCF have kind of
Right.
thing, whether or not they could be potentially houses. Right. But you're right in the sense that the way it is right now, they would be subject to DCF jurisdiction and supervision. Yes, that could be a placement somewhere. Maybe it would be more community-based treatment. You know, that's sort of their area of jurisdiction would be an age 10-year-old or an 11-year-old. That's the way it is now. Yes.
So until 18?
Well, no, potentially, but actually starting at, I believe it's 14. You're talking about committing a homicide, right? A murder. Once you start at age 14, then it starts in the criminal.
Can be a criminal.
Yeah, it would be. It would have to start in criminal if it's age
Right.
14 and up.
And that won't change?
Correct. Correct.
So going back to under 14.
Yep.
So the only age we're leaving out right now is 13. So we're going up to 12, right? Then the criminal starts at 14. So
I'll double check, but I think that means the 13-year-olds still start in the family division. I think that's what that
okay.
means.
Okay. So there's not a lot changing with that.
No, it's just just a couple of years of age range, I think. Yeah, and the whether or not you treat murder differently than you treat all other criminal offenses.
Yeah, I guess what I'm saying is either way, somebody under 14 years old isn't going to jail for 30 years or whatever, no matter.
Under 14. That's
Right.
Yeah.
But in the way it is now, somebody 14 could potentially go to jail for 30 years.
Yes.
So
That doesn't change.
right.
Yep.
Okay, so yeah, I just wanted to get it straight in my head that
Yeah.
there's not a whole lot changing, but a little bit. Or just
Okay.
So just to get it clear in my head, because now I'm confused. Probably was. This is murder only?
Correct.
So tell me one more time. Tell me one more time how this works.
So right now, the sort of bottom threshold, the minimum age that somebody's got to be, a child has to be, in order to be brought into the family division on a juvenile proceeding, right? For some illegal offense, whatever it is.
Yep.
Generally speaking, that minimum age is 10.
Okay.
That's right now. Now, the bill proposes, hey, we're going to bump that up to 12. But there's an exception for murder. And right now, so even though that minimum age is 10 for everything else, to get into to be a juvenile, for murder, there is no minimum age. So you could be 9, 8, 7, 6, whatever. Anything below 10 could conceivably be charged as a juvenile offense in the family division if it's murder, only for that one offense. For everything else, minimum age is 10. So if you're below age 10, 9, 8, 7, 6, you can't be brought into it can't be a juvenile proceeding against you in the family division. Like I said, it might be relevant in the context of a situation where, say, DCF is bringing a termination of parental rights proceeding, or maybe there's a CHINS proceeding against the kid. The fact that you committed this criminal offense could be relevant in that situation, but you can't be essentially charged in the family division as a juvenile if you're under age 10, with that one exception, murder.
Understand that.
Yeah, so the change is to say, we're not going to have that exception for murder. You can, if you're under age 12, because the other thing is it bumps it up to 12, but if you're under age 12, no juvenile proceedings against you, regardless of what the offense is. So as a practical matter, that only changes the sort of state of the law with respect to murder, because that's the only exception there is, right?
So the judge would have to follow those rules
Yeah.
that are set in place. That's the way it is. And then DCF, they're the only entity that makes a decision what happens and how it happens from that point on.
No, I think I was just sort of putting out there that the fact that the child had committed this what would otherwise be an unlawful act still an unlawful act, it's just whether the court can hear it or not, how it might come up otherwise. As you say, the court rule of, the court being the family division, the rule that, hey, here's the age range where you can have children come in juvenile proceedings, that's, would be pretty clear. You know, it's 10 right now, it would be 12. And the proposal is that there's no exception for any particular type of offense. So that line is pretty clear, right? Age limit is 12. The way that DCF could potentially be involved is, well, even though there couldn't be a juvenile proceeding against the child, maybe there's a CHINS proceeding. Maybe there's a proceeding where it's alleged that the child is in need of care or supervision by the state, and you know that they have a situation going on at home that proves.
They're the only ones that are, sorry to interrupt.
No, go ahead.
They're the only ones that are going to make that decision, right?
No, that'd be a court decision. The court has to make the finding.
So a question, so
Thank you.
Yeah, you bet.
individuals in the family court, is there a similar proceeding as far as competency, competent to stand trial? It's not just in criminal court?
That's an interesting question.
The reason I ask is I was kind of checking on one of the statements that Marshall Paul made, and there's a couple rationales for getting rid of this. One of them is that nobody could remember there being a murder by somebody under 12. You know, all of our witnesses, nobody could point to where that actually has happened. But Marshall mentioned for individuals 10 and 11 who are charged with a crime other than murder, you know, and under current law, they are delinquent, right? That the times that he's had anybody 10 and 11, they've been incompetent to stand trial. And I just want to, you know, so the 10 and 11-year-olds are not even really being adjudicated in family court because they're found not competent to stand trial. But I'd like to truth check as far as where the competency determination is made for juveniles.
Right. I'm not certain of the statutory reference, but I would think as a constitutional matter that you can't try somebody who's incompetent for a crime that doesn't understand. That's a constitutional rule, the nature of the charges against them. That derives from due process. So I would think that is a true statement, although I don't know the statutory.
Yeah, it'd just be interesting to know the statutory yeah.
Right.
Vermont Family Rule Procedure 1, subsection I, determination of competency of a subject of delinquency proceedings. Competency can always be brought up as a defense.
Oh, okay, thanks. But no, there we go. All right, so
Thank you.
because, you know, that's one of the other rationales why even moving the murder part, because they're not going to be found competent to stand trial, or at least, well, unlikely from what Marshall was telling us.
Right.
Okay.
Any other questions on this particular piece? All righty then. Also, I'll move on. No changes to section 2. This is the provision, you may recall, that allows the family court to extend jurisdiction if the child is charged with delinquency at age 16, 17, or 18 years of age. The family court already has that authority. They can already extend jurisdiction past the 18th birthday, which is when it usually ends. And this provides them with one more year, essentially. So 16 and 17-year-olds, the court, under current law, can extend the jurisdiction to their 19th birthday. Proposal is they can extend it to their 20th, bumps it up by a year for children charged as 18-year-olds as well. That brings us to the raise the age section. You may recall here that under current law, raise the age is supposed to go into effect April 1st, 2025. Proposal is to put a pause on that for 2 more years. So the April 1st, 2025 effective date would be repealed. That's what you see in sections 3 and 4. And then sections 5 through 9 will go into effect in 2 years, so 2027. That, and no changes there. So then you'll see section 10 is struck. That starts on page 6. This is you may recall that There had been a lengthy discussion during the previous meeting about whether or not DCF has authority to take physical custody of a child when they've been charged with a juvenile violation. There was quite a bit of testimony about that. And the proposal had been to make, and there seemed to be at one point some ambiguity. So the proposal you see on page 8, lines 3 and 4, the proposal had been to add a new subdivision 8 that specifically says if the child's 18 but not 22, and that was who this debate was about, by the way. It wasn't that there was any lack of clarity for children under age 18, but with 18 and over, that there might have been some need for clarity about. So that's what you proposed to put in. Said, hey, for that age range, one of the things that the juvenile disposition order can do is direct the commissioner to take physical custody of the person. But I think after testimony and discussion, it became clear that the agency or DCF already has that authority. So I think the conclusion was that there wasn't any need to add it, just for the sake of being able to switch screens here more. It's my first time Zooming with this iPad, so I'm going to experiment and see if I can switch my screens. Did that work?
Yeah.
Excellent. So this was to show that, well, if someone says, well, where it isn't current law, well, someone I'm sure was about to say, where is it? And so if you look at subdivision 16C, this is existing Title 3351, 51.4, I think it is. So let's go to the top real quick. 5102, sorry. Look at 16C. This is existing. You see one of the things that custody is defined specifically, subdivision C, for individuals who are 18 years of age or older. So they can be taken into custody. Status created by court order that invests in the commissioner the authority to make decisions regarding placements. So that's, I think, a pretty clear statement that they have the authority to place the child now or take physical custody of the child now.
I'll just comment that on our website on Wednesday of last week, or you can look up under Lindy Boudreau. She sent an email to us clarifying that this is not a legal issue, although I think that the email did mention that it's, they don't have the physical space. So, and one other comment about that section as well is that was our second attempt that we made on trying to provide more accountability, because we heard about this accountability gap, and neither of our attempts worked, and we will continue to work on that. I think that Tucker Jones did raise another possibility, but it's going to take a little longer to kind of flesh that out. So that's not good, but that's what that section is. Slowly, we're getting rid of things from this bill. So tried to do the ping pong effect, and was not successful in that one either, but it has.
So moving on now to section 10, this is with the deferred implementation date of raise the age. So that means you've got 2 years out until 2027 until raise the age goes into effect. As that has happened a couple of times over the years, when the implementation date of raise age, or at least the second part of raise age, the age of the 19-year-olds, as that has been paused a couple of other times simultaneously, the legislature has requested, or required, I should say, that DCF provide progress reports as to how they're doing. How are they getting closer to being able to implement the raise the age initiative to have 19-year-olds go into the family division? So this section that you're looking at here, section 10, is exactly that, asking for progress reports from AHS about how it's going. You'll see a couple of changes that are proposed, line 14. So initially it had been 3 different progress reports, December of this year, July and December of next year. So it backs that off to 2. So it'll be July 2026 and December 2026. Also adds, I think it was Representative Dolan who spotted this, that the Senate Committee on Institutions wasn't as one of the recipients of the progress reports, but now they are, in the Senate at least, the committee that deals with corrections issues. So it makes sense for them to be one of the recipients. So they're added. Other than that, there was a change asked here by the Department of State's attorneys on line 16. Page 9, that's just so that there won't be any ambiguity because the word youth could be interpreted to mean just youthful offenders when that's not what it is. It's about childhood, not youth. So that's just removing any possible misinterpretation there. Another section that's struck, you'll see on another subsection I see starting on page 10, you'll see this was a transition plan. This was the idea of, well, if, whenever raise the age goes into effect, there's going to be, or there will probably be, cases that have already started against children who would have did start in the criminal division as adults because they were, say, 19 years old before July 1st, 2027, before it went into effect. So the question would be, well, what should happen to that group of kids? Should they stay in the criminal division or should they be moved over to the family division? Because after July 1st of that year, if you're that age, that's where you start. So the initial idea had been to have DCF as part of their report, or AHS, I should say, include a plan for what to do with kids in that situation, referred to as a transition plan. But I think the testimony that the committee heard was that the court and the practitioners, because this has happened once before. This happened with 18-year-olds in 2020. Same situation. You had 18-year-olds at that time who were already in the juvenile, or sorry, in the criminal system, but who would have been in the juvenile system, but for the date on which they had been charged in the juvenile proceedings. So the court and the practitioners, the Defender General's Office and PCF, state's attorneys, had to figure out how to deal with those. And evidently they came up with a way that seemed to be satisfactory to everybody as to how to deal with them. So I think the decision was to not disturb that process. They figured it out before, rather than try and legislatively mandate how to figure that out when apparently they had come to a solution that, as far as we could tell from the testimony, everyone seemed satisfied with. There was no reason to try and put one in legislation. So that's why that part is struck. There is an additional piece added to the report, but you see that subsection B that's highlighted. This is a data report about the Red Clover treatment facility. So this asks AHS as part of the report to come back and provide utilization data for Red Clover, including how many youths utilize it on a monthly and annual basis, how long they stay there, the treatment needs of the youths who are there, racial and gender demographic data, and any other data that's deemed relevant by the department.
And I ran that language by the chair of Human Services as well as Ann Donahue, and both would like this in there, is my understanding. We'll further understand that when we present this to the whole committee tomorrow. When I present.
Good. Sounds good. That's really it. Some technical pieces to make sure the effective dates are squared up, and we don't need that language about in lines 12 and 13 about only applying the proceedings filed after the effective date, because as I was just saying, the practitioners and the court have already worked out how that how the Raise the Age initiative applies to kids that are already in the system.
I assume that the some of the like on line 10 on page 11 that it's not going to be section 10 any longer once everything's, or is it section 10?
Yes, yeah, it has been renumbered. Yep.
Okay, so it doesn't reflect. I see. Yeah, okay. Yeah. Questions for Eric? Karen?
It's not a question for Eric, but wondering if you can just provide context to us of what are the next steps with this bill?
So I believe we have Erica Radke and maybe Lindy Boudreau are on Zoom, and they're gonna weigh in on I thought that really was the main changes. I didn't think we needed to have march everybody else back here because we kind of heard about the stuff, but we didn't hear about that last provision that was added at subsection B that we added on page 10 and 11. So we hadn't heard from them on that one. So that's the main thing, but they're welcome. Obviously, if we go over to them, they can weigh in on any of the other parts if they wish. So I think that's it. Any questions though for Eric? Yeah, Ian.
Is there any definition of childhood?
Child, as opposed to child,
Yeah,
not that I'm aware of.
so we're just removing youth and we're adding a term that doesn't have a definition. So we could just strike from childhood and just say programming to help children, particularly 18, 19-year-olds transition to adulthood.
Yeah,
Yeah.
I like that.
It's a definition
Can you
of
repeat what you
adulthood.
just said?
It seems like the logical.
I'm not trying to drag this out I'm not trying to be difficult. We had some conversation before about definitions of like a youth or a child. And so we struck youth, and I guess I see what the state's attorneys were thinking about that. But we're adding in a term that doesn't have a definition, which just seems like not necessary when we could just strike from and childhood so that page 9, line 15 and 16 read, programming to help children, particularly 18 and 19-year-olds, transition to adulthood.
Yeah, and I guess, I mean, adulthood is not necessarily defined, but I think it's in the context. I mean, in context, I think it makes sense, and it's just for a report. And, you know,
Doesn't adulthood start at 18?
yeah,
Well,
I know, I have an issue with that language too, even with children being 18 and 19-year-olds.
so I can tell you though that this was, I think that language was, other than the youth changing to childhood, was taken from a law that passed last year and led to these perfectly good reports from DCF.
Yeah, that was verbatim what was in
I
mine.
don't want to change this too much because I want them to essentially be doing the same reports that they were providing like 4 or 5. And I think there's one coming very soon too. There's one more report that we're going to see. And I think those are all online. So, I mean, it's not a huge deal because it's leading to the report. I think having it from youth to adulthood is actually fine. Let's just keep the language that we had before would be what I would suggest. I mean, because they understand it, or we can ask our 2 witnesses what they prefer. Why don't we have our 2 witnesses?
I like your idea.
Yeah.
Say what?
What?
I like the Ian's idea of just putting transition to adulthood.
I'm fine with that as well, but let's find out from the witnesses, since they're gonna do the reports, if it's clear.
Just before they start, man,
Yeah, absolutely, Ken.
why do we need adulthood in there? Why not just adults?
Why don't we ask our 2 witnesses what they would like to see in this?
I shouldn't have brought it.
No.
No, I think it's a good one.
So, I think this question's for Eric. Is there gonna be any confusion because with a lot of stuff that we do, 18 is an adult?
No, it's a jury.
Right.
I don't think so in this particular case.
Okay.
It's just a reporting requirement. It's not the kind of thing that's going to come up in any litigation scenario. And adult does vary depending on the situation. It's different legal rights attach at different ages. It's not always 18 or not always 21. You know, the age of drinking, for example, is different than the age of joining the military. You know, it's different. So I think it'll probably be interpreted practically the same way they interpreted it last year. But you're right, it's a good question to ask. Maybe ask them, hey, was that terminology cause any problems when you guys put the report together?
Yeah, I don't have any issue with the language that Ian is proposing. After fine explanation by the counselor.
I appreciate that. Thanks.
All right. Any other questions on language for Eric? Or should we go to our other witnesses?
Should I get off the screen? So
I
you can,
think so, so we can see our other people.
I'm only,
The quicker the better, actually. All right, so Deputy Commissioner Radke and also Lindy Boudreau, whoever wants to pick us off, and hopefully and ultimately. So identify yourself for the record and proceed. Thank you for being here.
Absolutely. Good afternoon, Chairman Lalonde and members of the committee. For the record, my name is Erica Radke, Deputy Commissioner of the Family Services Division of DCF. Today I have with me Lindy Boudreau, Director of the Family Services Division's Adolescent Services Unit. Again, thank you just for the opportunity to talk about H2. I mean, we've been going back and forth, and we can see just so much of the work that you all have been doing, trying to accommodate all of these varying perspectives in the bill. So I just want to be, pretty quick and tell you that we do believe the department can support the bill as it's written now. We appreciate the changes that have been made. And in order to just respect everybody's time, what I want to do is pivot quickly to ask Lindy to discuss a couple of recommendations we have for Section 8. And then we're happy to answer any other questions that the committee might have about how the bill impacts our work or anything else you'd want to know about our position on Raise the Age. Lindy, go ahead.
Thank you. So for the record, Lindy Boudreau, I'm the Adolescent Services Director for Family Services. I was taking a couple of notes that the committee was questions that you all had. As Deputy Commissioner Radke mentioned, we do support the bill as written. I have one suggestion in Section 8. And I testified to this last week, but I just want to reiterate my recommendation would be in regards to jurisdiction, extended jurisdiction for 19-year-olds when that goes into effect in 2027, that rather than having the language state 6 months beyond the 22nd birthday, that jurisdiction end at age 22 for that population only, just because it would align with our age end of jurisdiction for youthful offenders. And as we've mentioned several times throughout the Raise the Age process over the past 10 years, these statutes are very confusing anyway. So I just put that out as a suggestion for the committee to consider. Just another point that I want to make, there was a question raised about the 13-year-olds. 5201 and C and D addresses jurisdiction for 13-year-olds. So that is not, it's not absent from the statute, it's included in there. So 5201D talks about the Big 11 and how the cases are handled for 13-year-olds. 5201C talks about all other cases. Regarding the question the last question that was just raised, line 8, the childhood to adulthood, I would recommend, I'm not sure why the state's attorneys wanted to add, I think it was the state's attorneys, maybe you said DPS wanted to add the term childhood. I think it would be fine if we just said transition to adulthood. That is language that we use at DCF in relation to our transition age youth. So it's consistent with our practice. I'm not sure if I covered all the questions. I tried to make all the notes, so I'll open it up if there's other questions.
Other questions? And you're fine with the new language that's in subsection B, the additional reporting requirement on the Red Clover Treatment Facility?
Yeah,
Yes, that's fine. Oh,
Okay.
sorry.
Okay.
we've been providing some of that data already for our deputy secretary. So, and it's important data. So we're really happy to provide that in the report as well.
Great, I appreciate it. All right, so any other questions for the witnesses? Yeah, Eric, go ahead.
I might have missed something. I got the change when you mentioned on page 5 regarding the extension of jurisdiction to the 22nd birthday. Was there, when I was jotting that down, when you might have mentioned one right after that, so I missed it. Is there another one?
On that section, no. It would just be we would remove the 6 months prior or 6 months.
Right. I got that. I mean, I thought you meant you went on to something else.
I think
that I didn't catch it.
I think that was Ian's language, the transition to adults.
Oh, okay, there was nothing between those two.
No.
Okay. All right, perfect, thanks.
So, all right, so why don't we have a little bit of a discussion to see where we are. So the next steps is I'm hoping to get everybody to understand where everybody is on this. Hopefully we're all on board with what we have here, or close to everybody. Doesn't have to be everybody, obviously, but at least a majority. I want to know that we at least have a majority of folks who are in favor of this. because Eric and I are going to go present this to the Senate Judiciary tomorrow morning. And the reason, this is a little odd, since even before we pass it, we're going to actually present it to them to see if they have any red flags, because the idea is that once it gets there, they'll take some testimony, hopefully the day after crossover, and move the bill, just so we can have it passed in time for the April 1st. So I'm going to be presenting it. Eric and I will present it tomorrow, and that's kind of why I want to make sure that we're solid in here at this point. And then also going to be presenting it to Human Services, and if they're mainly going to be focusing on the report, but I'm not anticipating any big issue there. But it's kind of a courtesy of running it by them. So with that, it seems like the one additional change, and I will leave it to how Eric will draft it. I could see it's probably fairly straightforward to have the 6 months beyond the child's 20th birthday and 6 months beyond the child's 21st birthday, and then the 22nd birthday or something along those lines. Are people fine with that? Folks fine with that? I mean, it makes sense. Yeah, it made sense. And sorry we missed that you had brought that up the other day, Lindy, but we've kind of overlooked that comment.
Which one was that again?
It's changing this here. So this is going to be not just 6 months beyond on page 5. So let me ask, any concerns? Are folks fine with this? Are there areas that folks are concerned with? Besides being frustrated and delaying things for two years, which we've gone over that, but anything else are people generally fine with this?
So this is still delaying, raise the age until 2027.
Yeah, July 1st, 2027.
But we're not voting on it right now.
No, but I want to understand if before I go and present this to the Senate and the Human Services, I want to know that we're solid in here. I mean, I could do a straw poll.
Yeah, but you could go and we could talk about something else, and then we could come back and do a straw poll after I do some heavy thinking by myself.
All right, so is most everybody else okay with this without more heavy thinking? Zach?
I mean, you don't have a view. So my thinking behind it, Mark, is principally I would rather see the delay of implementation totally separate from H2.
Right.
And I'm pretty staunchly, of that viewpoint. So that I would rather have pure vote of delay of implementation, and then all the youthful offender language can be voted on in a separate bill.
Yeah, I understand that.
So for that reason, I'm a no.
All right. Okay, fair enough. Anybody else? Just if we get enough no's, we'll be able to have this go ahead in April 1st. So,
well, that's kind of a thready way.
That's not a threat. That's just the way that's just
I'm
the
still
fact of it. Yeah, no, that's fine. No.
No.
But I just want to,
Regardless what happens on April 1st.
I just need 6.
I would say this, my lack of support for the bill in its current form is certainly not an endorsement of raise the age.
Right.
So like those two issues should not be confused.
Understood. Yeah, absolutely understood that.
I just want it for the record.
Yeah. No, that's good. Make that clear on the record.
Yeah.
I like that. Absolutely. Karen.
It's interesting. I was going to say I support, but maybe we let it go. Yeah, no, I won't. I feel like this is a good compromise. My goal is to have raise the age move forward, and I also want it to be successful. So I feel like this is the compromise that we need. So I supporting it, appreciate the work that we did. And I like that we're keeping everything together all around the juvenile jurisdiction. Because I like to call it the raise the age ×2, because we're raising the age at both sides. So we're talking about raise the age both sides.
Yeah, and just I guess further comment for Zach, and again, it's absolutely fine where you are, but in my thinking on this bill is that a lot of people are going to have a lot of trouble on the floor with just delaying the raise the age. And frankly, I'm not sure if I could pass something that's solely delaying raise the age. So there's other things that will bring people along. So
That's my concern.
Yeah.
Well, to be honest, that's my concern.
Yeah, but I guess the question is, if are you opposed to the other things? I'm just kind of curious about that.
Yeah, I am.
All right, okay, fair enough, yeah.
Dan, your point of view, but what are those of us that are fine with repealing it?
I understand that as well. The delay is part of the compromise there as well.
I think the delay is in my, I assume this is open discussion.
Yeah.
I mean, my thinking is the delay is the compromise, you know, because I think there are many of us on the committee and in the broader caucus in the House that would want to repeal entirely.
Right, sure.
So I think the delay is about as far as we can probably get to the middle.
Well, the other thing I just said is that we have the administration or DCF saying that they support it. So like that's also pulls a lot of weight for me as well, saying that they appreciate the bill in this form and with these pieces. So these are the folks who are on the ground doing the work. And if they support it, I'm like, okay, this makes sense.
Yeah, I got a question around that. So, does the administration support it or not, go against it
Like,
and not opposed to it?
Mommy, does it work?
No wrong answer. I think I know the answer.
I did too.
I think I heard support earlier, but.
That's
Well,
what
I
I
think I
heard.
did too, but I just wanted to be clear. Is it support or not
That's an
opposed?
answer, I think.
I
Or
like,
you can think about it.
I like the asked and answered. I think that works. for
You like the what?
Asked and answered. I think that we can go back and see the testimony and what support I do.
I do think,
Okay, no, that's fine.
I do have a point, like piggybacking on what Tom was saying, a point of clarification. The endorsement of DCF is not an endorsement from the governor and the administration.
But it's the group that is implementing the work on the ground.
No, I understand that, Karen, fully, but like, I'm just saying, I mean, unless we have a spokesperson for the governor himself in here.
Yeah.
Like, I understand that they're doing the great work on the ground with DCF, but that's not an endorsement from Governor Scott.
So maybe I appreciate.
So I just don't want to
that support
conflate
from-
I don't want to conflate the
Yeah.
two.
Right.
Like,
Yeah.
I understand that they're implementing what is going to be happening here, but it's a different thing in my mind.
Well, this is clearly what I've heard from Governor Scott. He does not want the age raised. That's come direct out of his press conferences and all that stuff. So this bill here, to me, is either we take and we accept this and we kick the can down the road to delay, immediately raise the age of from 18 to 19. All we're doing is we're making a deal, and then the two-step process that Rep. Dolan said is you get the increase on the younger age. So it's like I'm just gonna say it, it's like politics at its best. You're given something and we have to give something. And I'm not comfortable. I wish we just had a bill that was just repeal, raise the age. But instead we have this bill here. And I don't mean this in a negative, bad way, but we have this bill here for political reasons. That's my feeling.
Sure, there's part of that. I'll go a little bit further than that. And certainly I took the repeal, raise the age as a starting position of the administration. And I took that April 1st this was going forward as a starting position on those who are supporting raise the age. And we've reached a compromise on that particular component of this, and that's the delay.
Who reached a compromise? What do you mean by that?
Well, I feel this is compromise language.
Oh, that's your
This is-
compromise?
Yes, I feel this is
Okay.
compromise language.
Okay.
It's,
It's not a known compromise.
what's that?
It's not a known compromise with the.
I don't know if the others.
Section or-
Right. No, that's true too. So the other thing we did is that we took a deep dive into juvenile jurisdiction, and we wanted to find out what other issues there are there that we could try to resolve. And we did try to resolve the ping pong effect. That's being delayed until we hear back from this task force in December. We tried two different approaches to deal with the accountability issue, and that didn't quite work, and we'll continue to work on that. And we have the other issues that I think that we resolved, which is raising the lower age, raising the age of how long people could be in there, and then having the report as well. So I think, I wanted to do as much as we could with juvenile justice in this. It was going to be a much bigger bill with many more things resolved, but we didn't quite work out that way. So this is what is left, essentially. Yeah.
Yeah, I don't know if we need a straw poll. I mean, it's gone as far as it's gone. I don't foresee any more changes coming. And if you want to bring it down and propose it to the Senate before it's voted out of here, I don't have an issue with that, but I don't, right now, I don't see where any kind of a vote is necessary, because what if the Senate has a big change that they want to do, and then we bring it back and we're gonna vote on something completely different.
Right. No, I understand.
Let it
agree with that.
As far as the votes go, let it lie where it lies right now.
Yep.
I'm not happy about everything. I'm not, against everything. I do know that if this bill was never taken up, that April 1st would have been all hell breaking loose in DCF.
Still currently is.
Yeah, right. I mean,
Right, it is, yeah, it still currently is, so, yeah, I guess I would be against any kind of a vote right now.
Yeah, no, that's fine. I see what you mean. Yeah, I mean, we gotta
Let's
see
get-
what the other people say.
Let's make sure we have the final version.
Right, it's,
Because
yeah,
we don't necessarily have. the
absolutely.
final version.
No, I appreciate that. Tom, I do. So we do have the vote scheduled for Thursday morning, and, but I will report back, we'll have something by the end of the day, the version 5.1, and we'll see if there's any kind of changes that we believe that we need to make, given Senate input, if that's what's going to be necessary to get it through the Senate rapidly. But I don't anticipate that, but we're just double checking tomorrow. Same with Human Services. Because I've kept the chair of the Senate Judiciary informed of the work that we've been doing on this bill, just so not going to be a surprise, but we do want to to look at. So, all right. So let's take a 10-minute break, and 2:00 we're going to hear from Michelle with walkthrough